So hello, everybody, and welcome to Conversations with ICC Australia. We're really delighted to have you all with us today. The idea of this new series is basically to get together online once a month with the ICC Australia community and to talk about things that may be of interest to everybody. So we're really lucky today to have Professor Doug Jones with us. Professor Doug Jones AO is a leading international commercial and investor state arbitrator and an international judge of the Singapore International Commercial Court. He has offices in Sydney, Toronto, and London. He speaks and publishes widely and has received many accolades in recognition of his contribution to this field, including being appointed as an officer of the Order of Australia for distinguished service to the law. So we're very lucky to have Doug with us, sharing his insights. My name is Emily Hay. I'm counsel at Honotua and Vandenberg in Brussels. I work as counsel, arbitrator, and tribunal secretary in international commercial and investor state arbitrations, and I currently split my time between Brussels and Taipei. My cases cover a range of sectors as well, but I have a special interest in data protection, new technology, and ESG-related disputes. So we just have 30 minutes today with everybody, and we'll try and reserve some time for questions at the end. So please put your questions in the chat. And to get us started, Doug, how about you tell us, how did you end up working in international arbitration, and how did you transition from counsel to arbitrator work?
Well, Emily, it's a great pleasure to inaugurate with you this event. I think it's a wonderful thing to be able to bring together the Australian arbitral community. We've got a great diaspora around the world, and catching up with each other is something that is to be worked on. And I think you're to be congratulated for initiating this. How did I get into international arbitration? Well, my first love, I suppose, as a lawyer has been construction law, a love which not every lawyer shares, but something that I've been fascinated with for many years. And it's been my privilege in that field to do a number of international projects from a base in Australia, where, of course, international arbitration is the preferred method of dispute resolution in international construction projects. So in my practice as a construction lawyer and a projects lawyer, I got involved inevitably in international arbitration disputes for many years as counsel. But then after a while, towards the end of my career as a member of a law firm, I started to get some appointments as an arbitrator. And I think to keep oneself alive and interested in life, one needs to reinvent oneself from time to time. So in 2014, I moved from being a partner in a law firm to try a full-time career as an international arbitrator. And that has proved for me successful in the sense that I am now blessed with a range of fascinating cases which extend beyond construction, although it remains, of course, my first love. And as an Australian, I've had to realise that, sadly, at least for my professional career, practising as an international arbitrator wholly based in Australia would not be effective. So that is how my sort of international bases have developed. And I'm speaking to you today from London, where a significant part of my work is presently located. And what about you? How did you get into this field?
Fantastic. Yeah, I was a little bit the opposite. I started abroad and now shifting my focus more towards Australia. So I was a little bit by accident to end up in arbitration. I wanted to work in public international law. I found myself in Brussels and I was looking for a way to stay there. And after talking to a lot of people, I realized private practice in arbitration is a great way to combine a legal career outside your home jurisdiction with a lot of other things that I love, like international law, different cultures, different legal traditions, very challenging cases, and lots of fantastic people. So that's how I ended up in the field, and I didn't look back.
So, Emily, some of the people who catch the arbitration bug do so from the perspective that you've mentioned, that is public international law. But of course, in international arbitration, there is far more commercial arbitration than there is public international law related arbitration. How have you found that? Have you been interested or disappointed by finding that there's perhaps not as much public international law around as there is commercial?
Yeah, that was, I think, one of my big surprises, actually, that I love the commercial side. And I do work on investor treaty cases, but I have to say that the commercial ones are my favorite because every one is a different challenge. Every contract is a different mess. And it turns out, I think, that I like the commercial cases even more than the investment cases, even if investment cases are very exciting as well.
That's really interesting, because I think that a lot of the sort of public debate one hears at conferences and the like, and certainly a lot of PhD theses in the subject of international arbitration concentrate in the ISDS space. But you're absolutely right. I share with you the fascination of commercial arbitration, because there's a different law, there's a different contract, there's a different sort of project, there's a different sort of transaction each time around, and it's just so stimulating.
Yeah, I fully agree. So turning to today's topic, we're going to talk about active case management, and in particular how arbitrators can ensure that proceedings are conducted efficiently and cost effectively. So to go back to the rules here, we're talking about the ICC rules, Article 22, paragraphs 1 and 2. This is where the arbitral tribunals and the parties shall make every effort to conduct the arbitration in an expeditious and cost-effective manner, having regard to the complexity and value of the dispute. And in paragraph 2, we have that in order to ensure effective case management, after consulting the parties, the arbitral tribunal shall adopt such procedural measures as it considers appropriate, provided they're not contrary to agreement of the parties. And there are a number of measures that may be appropriate there. So we also see this in a number of other procedural rules with similar provisions, such as AKICA rules in Article 25.2. And so, Doug, one of the very costly and time-consuming aspects of arbitral proceedings is the management of party-appointed experts. And what strategies do you have for streamlining this process?
Well, having practiced as a common lawyer in the Australian domestic jurisdiction inevitably for years, the challenges of actually getting valuable evidence from party-appointed arbitrators has remained a constant in Australia, and I think a number of other common law jurisdictions, not just in arbitration, but if you take sort of medical negligence cases or indeed personal injury cases, getting a doctor who's independent has always proved to be a challenge. So in international arbitration, the concept of having party-appointed arbitrators seems to have been embraced enthusiastically by civil lawyers who haven't had that long history of the failure of the process of party-appointed arbitrators to draw upon with their experience. And one sees in practice in commercial arbitration and indeed in ISDS arbitrations that there is very rarely adopted a tribunal-appointed expert approach. So you face the challenge of party-appointed experts on a constant basis. And the difficulty that common law jurisdictions domestically have had of actually getting some independent help from experts is writ large in international arbitration. And as a consequence, one often sees experts passing, as we say, like ships in the night, talking about different things when they're supposed to be experts in the same field. So it's been a bit of an epiphany for me to try to find ways of making that more effective. I must say that over the last few years, I've found some techniques that I think actually increase the value and the help that experts can provide to tribunals and indeed to the parties. I find that persuading parties to adopt processes that perhaps aren't as traditional as they have been used to is is a challenge, but certainly one that is rewarding if taken up.
Yeah, and when you do get pushback from parties and counsel, how do you sort of shift through that in the proceedings?
Well, I regard every arbitration as arbmed, in the sense that you arbitrate and decide the issues between the parties and you mediate the procedure. So finding a way forward in each case to adopt an effective procedure, including relating to experts, is very much a process of working with counsel and the parties so that you can persuade, cajole, encourage parties to think outside the rather limited square that lawyers have of what they like as procedure, and to move forward, perhaps as a joint experiment for some, to new processes. So it's not in any way, in my view, something that you impose as an arbitrator. There's a huge difference I've found between being an arbitrator and a judge. When you're a judge, you can tell parties what to do. When you're an arbitrator, you've got to carry with you the parties and the level of comfort that counsel need in order to feel that they're part of the process. Is that something that you've experienced yourself in terms of innovating procedure?
Yeah, I think there's definitely a lot of room for innovations to kind of streamline this expert process. I think it makes a lot of difference how big a case is, how complex it is, in order to tailor arrangements accordingly, because whether a particular procedure is going to save time and costs can really vary from one case to another. And it can also depend on how contentious the parties are, how what they consider important, because it can be really hard to withhold engaging an expert on a particular issue if the other side is doing so. So with that in mind, still, I think there is a lot of useful things you can do. First of all, there's the kind of discussions that you're talking about the tribunal can initiate, but even as counsel, I think you can explore ways to streamline agreements with the other side. You can also try to use joint expert reports. If you are using joint expert reports, I think a protocol to set out the basis for those discussions can be very helpful. Setting out the purposes of joint discussions, how you'll set agendas for meetings between the experts, who can attend those meetings, any without prejudice basis of discussions. And I think there's some useful tools out there, like the Chartered Institute of Arbitrators has a protocol, which can be helpful to inspire some language there. I think another way is to schedule a CMC that's just dedicated to this expert evidence. I think you have some CMC proposals that we can talk about in a second, but even if you're using a traditional sort of structure of proceedings where you have the statement of claim, statement of defense, and then document production, if you schedule a kind of CMC for the experts prior to document production, you can streamline that document production process, try and have the requests more targeted, and really focus the parties on what's going to be coming around in the second round of pleadings, what they should focus on. So yeah, I think that's narrowing document production it can be another really, really great priority. And maybe you can tell us a bit about these case management conferences and how you use them in your practice. I think I've heard of the midterm CMC.
Yes, I think proactive case management, which is what we're trying to talk about, is really a critical element of making arbitrations work. We talk forever at conferences about how to make arbitration more efficient and cost effective, but it's only with an engagement between the tribunal and counsel and the parties that you can achieve that. I must say I'm hugely encouraged to hear your comments about innovative procedure, because it's with the leaders of the future, such as yourself, that lie the opportunities to actually make this process work. So it's fascinating to hear the encouraging ideas that you've got. I sort of start off, obviously, with trying to organise the procedure that seems sensible for each case. And part of that, of course, is the expert procedure. In late 21, just as COVID was sort of fading, I was invited to give a paper at the ICC Institute in Paris on experts. And I gave quite a detailed paper that has subsequently been part of a publication that's just about to be issued of those proceedings, but it's also on my website, where there's an outline of how you might deal with experts. But no one case is the same as the next. And I'd have to say that even though I've got a model, the model is there to be adapted and used. But if you just try and set the arbitration on automatic from the start, it is often a sad surprise that you get when you come to the evidentiary hearing, because the process will have needed to be thought about and amended during the process. And so in that context, including with experts, I try to find a time during the case when you can actually make a difference after you've had perhaps an initial round of party submissions in devising how best to take the arbitration forward, given what's happened. And I call that an issues CMC, or a midterm case management conference, where I try to summarise for the parties what I think they're arguing about on the basis of their pleadings, and talk to them and their experts about how to adjust the process, how to manage the process from the midterm of the arbitration procedure through to the evidentiary hearing. Because there's no way you can invent in PO1 a process that will that you can run on automatic.
Yeah, I fully agree. And I think case management conferences can be a great way for a tribunal to engage with the specific needs of a case, get up to speed, and explore different ways that you could tailor the proceedings, and also to resolve disputes that arise more efficiently. There's just something about having everybody on the line together, even if it's virtually. There's a lot more direct communication, there's less posturing between the parties, and I think there's more space to reach agreements on things that can be really difficult to communicate about when you're communicating only in writing. So I think it's a really useful tool indeed.
Yes, I think you're right that there are some big issues that we don't adequately have answers to in both commercial and ISDS arbitration. One of them is experts, that you've mentioned already. The other is disclosure, which you've mentioned as well. Alan Redfern never thought, when he had his name attached to a schedule, that there'd be an adjective put in front of the description every time someone referred to it, usually an uncomplimentary adjective. And so it is that disclosure, hugely expensive, badly managed by tribunals, often because the decision-making process about what's to be disclosed comes at a point when you don't really know enough about the case to understand the relevance and materiality of what's being done. And the interrelationship between that and experts is one aspect of a process that I've found helps, because quite often you see in the Redfern schedule requests for disclosure that are clearly driven by what the experts have told a junior member of the legal team they'd like to see, and which the poor person involved in drafting the Redfern schedule has had to translate to ensure that they don't miss anything out. So you often get overdeveloped requests. And what I like to do is to say that if you want documents for experts, get the experts to confirm they need them and why. I mean, experts can over-ask as well, of course, because they always like perfection, but actually getting to the people that really need to use the documents is a way of solving some of the problems with disclosure.
Yeah, fantastic. I fully agree. I think some other really good uses of CMCs we saw during the pandemic were the hearing format CMC became a standard, I think, because it was too early at the beginning of the case to know what the situation was going to be by the time of the hearing. So you saw a lot of case management conferences and different views between parties about whether a hearing should take place in person or online. And I think also just on an ad hoc basis, case management conferences can help to resolve issues that have become sort of intractable in correspondence, or if the tribunal has questions for the parties, just to get everybody on the line together and to discuss, or if there's a site visit, the questions about the scope of submissions or things like that. So I think there's a lot of opportunity for active case management when it comes to CMCs.
I think COVID's given us a real chance to use technology in a way that would never previously been thought about. I mean, the maximum extent we used to go to pre-COVID was, say, we'd have a telephone conference call where you never saw the people and the communications were as stilted as they are over a loudspeaker on a telephone. Now we can see each other in virtual CMCs, and sometimes, of course, actually see each other face to face. But what it does, as you rightly identify, is enable a tribunal when it sees something intractable emerging, saying, okay, let's talk to each other face to face, virtually, about this problem. And it can diffuse a lot of the written submissions that then sort of proliferate when there's a difference of view between counsel.
Yeah, I fully agree. I wonder if we have any questions from the audience. Feel free to raise your hand or to write them in the chat, and you can ask them directly. Otherwise, while we're waiting, I wanted to ask Doug, have you seen much uptake of the Prague rules in terms of case management by parties in your cases?
Not adoption of the Prague rules, but there are a lot of ideas in the Prague rules that can be thought about. Limited disclosure, whether or not you can actually substitute for party-appointed experts, tribunal-appointed experts. I regard the Prague rules as a bit of a checklist of ideas, but I've never seen it actually adopted. Have you?
No, me neither. I've never seen it actually explicitly adopted in a case, but I agree that some of the tools are definitely being used, and even some of them quite commonplace. And even in ISDS cases, I've seen increasingly detailed provisions trying to narrow down the document production process and really contain that procedure to something that's more manageable, because it's not always the case that it is. And but yeah, I haven't seen it adopted explicitly, or I haven't seen a lot of uptake of tribunal appointed experts either, but I think that can be a really interesting opportunity as well.
Yeah, I think the Prague rules were a bit of the revenge of the Central European civil lawyers who say the IBA rules never really took account of what the civil law procedure can offer arbitration. So it's always useful to think about it, but to think about it in the context not of will you adopt them or not, but what sort of ideas can you get from them?
Yeah, I think it's a really good point. We might as well get inspiration from wherever we can of what things can increase the time and cost efficiency of the proceedings.
Yes. I mean, it was something that I sort of learned the hard way back in the day, that if you're in international arbitration, you need to leave your domestic baggage at the door. And psychologically, that's a really hard thing for lawyers who have a busy domestic practice as well as an international practice. Rethinking the toolkit with the baggage left at the door is something that is useful for arbitrators and for counsel, I think.
Definitely. So we have a question from Mark. Mark, do you want to ask your question directly?
Thank you, Emily. The audio may not be great where I am. So maybe you could ask it for me. Thank you.
Sure. Mark asked, what are the telltale signs that an expert is being partial? And separately, how do you narrow the differences between the experts to make it more efficient? Doug, do you want to start us?
Well, I could go on for quite some time on that subject, but let me try and encapsulate it. I think there's a process which involves the tribunal working with the experts to ensure that they understand what the tribunal is looking for. So I have a process which I try and suggest, which starts with identifying the experts, in each area of expertise, getting an agreement between the parties or settled by the tribunal and the experts of what the experts are to opine upon in each area of expertise, then getting the experts to talk to each other with the benefit of a common database as to what their views are, if any, on agreeing what the answers are to those questions. And then only then producing individual reports where they explain why they disagree with each other. And in that process, it is exceptionally useful for the tribunal to be seeing the experts, usually virtually, regularly. You see a report, you say, well, you could probably do a little bit better than that. Can we just have a chat about how you could help us, with counsel there, of course. And as a consequence of that, by the time you get to the hearing, the experts are really trying to help the tribunal, because that's what they would really like to do. And I don't want to scare the horses by saying that counsel control of experts, which of course is critical to being able to adequately present a case, does tend sometimes to limit the contribution that experts can make themselves to the opinions they're providing. So, Mark, to answer your question, I think you can see the biased experts from a long way off. It's the ones that disguise that make it more difficult. I remember back in the Australian domestic practice, it used to be said that the best expert is the apparently independent but wholly biased expert. So the ones that aren't so obvious are the ones you need to be careful of, but the ones that are obvious, you can see them from way back.
Yeah, I think that's really true. And I think the active case management tools that we've talked about today are a good way to get an indication a lot earlier about that sort of telltale sign, because otherwise I think cross-examination is a very telling moment as well for an expert. But if you can already identify some of these things earlier in the proceedings, then even better.
I did quite a few webinars during COVID with experts, just to let them say what they thought they could contribute to the advance of procedure in arbitration. And I never had any pushback from any expert to the proposition that they could add value and were trying to do so. So interesting.
Yeah, a lot of room for that. Jenny, do you want to ask your question, or would you like me to ask it for you?
I can ask it, but excuse the background noise. I mean, it's to both you and Doug. I was at a recent ICC arbitrators conference, and I was struck a lot of the arbitrators were obviously complaining about the length of counsel's pleadings, that many of the issues they were addressing they felt were irrelevant. And I was raising with many of these arbitrators why they weren't more engaged. And I'm thinking the midstream CMC is a good point to do this, in giving parties their initial thoughts on some of the issues in the case. So, tentatively with all the caveats necessary. But I think, and certainly speaking for myself, I think that would be welcomed by counsel to have initial indications from the tribunal, areas where they feel they might need more expert evidence, or areas that they feel are already covered and they're quite comfortable with and don't need to be addressed at length in the second set of submissions. And I wouldn't mind hearing from both of you if you feel comfortable doing that, if you have done that, and how that's been received by counsel, because I've rarely heard. It's sort of, Doug, what you were saying with experts. I think counsel would welcome direction from the tribunal if they feel they're in a position to give it.
Yeah, I think there are two aspects to your question, both important. The first is tribunals need to understand what it is that are being argued rather than just whinge about the length of what they're being given. What I try and do for a midstream CMC is summarise myself what I think the parties are arguing and give it to them, often in a tabular and different form to the way it's in the narrative pleadings. Give it to them before the CMC and say, have I properly understood what it is you're arguing? And then can you help me as to each of the issues I've identified in each party's position, where one finds that in the factual evidence, the expert evidence, and anything else that you might like to add in the reply material on the issue. When I first did that on a massively complex offshore oil processing thing in a New York seat, I remember then senior associate of a large international law firm saying to me, "You've missed the wood for the trees." And I really liked that because it gave me a chance to rethink how I was thinking about the case. So doing the work of actually working out what the parties are arguing is critical, rather than just saying to the parties, "I want you to present what you think your case is." Actually try and tell them what you think the case is. But the second issue you raise is a more tricky one, and that is letting the parties know in a preliminary way what you think about the issues at an early stage. That's a very German, Swiss sort of approach where a lot of arbitrators will run a mile from even thinking about doing that. I've never actually done it, and I'd be interested in watching that process if I have an opportunity to do it. But I don't think you need so much to express views about what you think, because counsel will know the case at a midstream CMC a lot better than any arbitrator will, even though you've tried to understand it, but rather to just test what the arguments are. I had an interesting Saudi case about a massive shopping hotel centre complex negligence claim against the architect, and it was a complete mystery at first glance in the pleadings as to what was being argued. And it took a while, but I broke it out into the various issues and gave it to the parties and said, "I'll see you at the midstream CMC." And a week later, they came back and said, "We'd like to defer the CMC because we're negotiating." And they settled about a month later. And I think, without overstating the value of the work I did, that they hadn't actually understood what each party's arguments were to the extent that I'd summarised it for them. And that enabled them to actually talk through it issue by issue. So it's interesting. But it's a critical question of getting on top of what the parties are saying well before you come to any evidentiary hearing. There's a reluctance among some arbitrators to do it because it's hard work.
Yeah, I think I agree. It's hard work, but well invested, as you've seen in some of your cases. And as Mark put a comment here, that's a brave senior associate that said you couldn't see the wood for the trees. I agree with that too. I have seen, because we are based in continental Europe, I have colleagues who are more of the German Swiss variety who have taken this very active kind of approach to expressing views, but always subject to applicable law and subject to the agreement of the parties. I think often it's even proposed by the parties that if they want to have those kinds of views, and a little bit closer to the evidentiary hearing, I think once the tribunal has digested fully what the parties had to say, I think there have been cases that I'm aware of where the tribunal has given some preliminary views, and in the same way as Doug is talking about, it often helped the parties to reach an agreement before an award was rendered. So it can be really beneficial for the resolution of the dispute, let's say. But something, I think definitely there are cultural differences and legal differences, and something to be approached with caution. So I think we're out of time. Our time was very short, but before we finish, Doug, I just wanted to ask you what's the best career advice that you've been given for our audience?
Well, it depends who you're giving it to. I suppose I've sort of worked my way into the field without the opportunity of too many advisors. But what I would say is take the opportunities as they come and don't leave any stone unkicked, because the opportunity to work in this field is one that's very greatly privileged to be able to do it. But there are a number of different areas in which you can work, and don't fix your intention inflexibly. take the opportunities as they come and follow them when they look prospective.
Yeah, I think I fully agree with that. I think I've received some great advice along the same lines that you don't really know what doors are going to open, and so you better follow opportunities that do arise, like you say, if they're promising ones, and it may not be what you expected, but it can turn out really well, and also not to be afraid to take on things that feel challenging or out of your depth, because that's really an opportunity to grow and often leads to something else. So it's wise to follow the open doors, let's say. So I wanted to thank you so much, Doug, for your time and for this great conversation. And thank you everyone for joining us for this inaugural episode of Conversations with ICC Australia. Please join us for our next episode. We'll be at the end of July. We'll announce the details of that soon. And thank you very much to everyone, and have a great day.
Thank you very much, Emily.